Thousands of Afghani refugees no longer have their protected status, meaning they can no longer stay in the U.S. and may be forced to return to a dangerous situation in their home country. Doug Reardon has more on the impact of this change.
On Monday, temporary protected status ended for thousands of Afghan refugees in the U.S. It means the people who were granted protection from the years-long war in their native country will now have to return back.
The TPS status is really designed for kind of an emergency use.
Emory University professor John Acevedo says TPS will usually last through the duration of a conflict or cleanup from a natural disaster. The Department of Homeland Security told me Monday, quote, Afghanistan has had an improved security situation and its stabilizing economy no longer prevent them from returning to their home countries, unquote. But Acevedo says while the country is solidly under Taliban command.
These are folks who are not going to be welcomed back by the Taliban. And some of these are also many women who went and became educated or were educated and worked as doctors, nurses, and teachers, and are also not going to be particularly welcomed back into Afghanistan.
Welcome back. This week, the U.S. Supreme Court gave the Trump administration the green light to move forward, at least temporarily, with plans to slash the federal workforce. The justices overwhelmingly sided with Trump's administration. Only one justice was disagreeing, calling the decision dangerous and overreaching. The ruling clears the way for deep workforce reductions. Some departments are preparing to cut half their staff. The decision does not decide whether the firings are legal. Ongoing lawsuits will determine if the executive order oversteps constitutional bounds. Here to make more sense of this and what we're hearing about it is Emory law professor Jonathan Nash. Jonathan, welcome to the show.
Thank you. Glad to be here.
All right. As we said, there's plenty of unanswered questions about this ruling. Why do you think the justices went the way that they did?
Well, I think the bottom line is that there are sort of two reasons. One is the challenge that was brought was too early. The government hadn't even had a chance to develop fully its plans to reduce the workforce across different government departments. And the other thing is that the executive order directed the agencies that are going to do this to do so in accordance with existing law. So there's no claim that the executive order on its face said, just go fire people. We don't care what the law says. And I think the court looked at that and said, well, that's what we have in place. We have to at least see what the government is going to do, how it's going to implement this before we declare anything proper or improper.
In your opinion, do you think the executive branch actually has that kind of power to bypass Congress and legally put the plan like this one into place?
Well, I think the court is saying no one's bypassed Congress yet. Now, it could be an issue. There will be. There already are some other litigations that are putting a pause on some of this. And if the government does try to bypass Congress, go beyond what Congress has authorized, then I do think you'll see lower courts and maybe the Supreme Court gets back into this saying you can't do that.
All right. So one justice, we talk about Justice Jackson, calling this the ruling a wrecking ball to the federal workforce. Legally speaking, is there any real check on how far this could go?
Well, I think the answer is yes. And Justice Sotomayor, in her concurring opinion, she joined the court and said, government can at least go forward and say what they're going to do. But once they say what they're planning, if what they're planning, as you put it, bypasses Congress, goes beyond what the law authorizes, then the courts do have the power, and it would be proper for the courts to stop this. And my guess is if that does happen, you'd get more than just those two justices saying it's not proper. Yeah. So there are limits here.
Okay. How might this affect the ongoing cases in the lower courts?
Well, like I said, there are some other litigations involving unionized employees, specific departments that have already put in place blocks on firing employees. Those cases are going to, I think, continue. I think you're also going to get more cases. You're likely to get cases department by department once these plans roll out, challenging what's happening. So I think you're likely to see that. The only other thing I'd say is this ruling is just a general statement to the lower courts. You can't just some lower court judges are just stopping what's going on too soon. You're not waiting until we see the actual contours here. Courts decide cases, the court is saying. They don't just say, this sounds dangerous. You can't do that. You have to actually see what the precise action the government's going to take is before the court should step in and enter an injunction to stop the government in its tracks.
Yeah. If you're a federal worker out there and you're watching this, what protections do you have?
Well, if you're unionized, you still have union protections, and beyond that, you have whatever civil service protections are in place that Congress put in place. You may also have courts stepping in to assert those rights as things continue. But it definitely is a time of uncertainty because the government is allowed to go forward and sort of say what it's going to do. And that backstop of an injunction isn't there anymore, a broad injunction. So we'll have to see, workers will have to see, we'll all have to see what the government comes up with, how they're planning to do this department by department, and assess it then.
All right, Professor Nash, really appreciate you joining us. Thanks for your insight today. All right, this past week, the U.S. Supreme Court handed down several key decisions which are likely to reshape legal fights well beyond this term. The court ruled that federal district courts cannot use or cannot issue nationwide injunctions unless necessary to fulfill projects and parties involved. The latest, this limits the power of lower courts to block federal policies across the country. Another ruling allows states to cut off Medicaid funding for reproductive health providers, even if those providers deliver no abortion services. The justice also decided that parents have a constitutional right to opt their children out of lessons involving LGBTQ storybooks if those materials conflict with sincerity held by religious beliefs. All right, joining us now is John Acevedo. He is the Emory professor at Emory University School of Law. Welcome to the show, my friend.
Thank you so much for having me.
All right. Welcome back, I should say. You've been on the show a couple of times. You're a friend of the show now. All right. All these rulings were a 6-3 split. How does this reinforce the perceived firm ideology split between the justices?
It most certainly is showing a fractured court here with our 6 conservative justices lumping together. It's interesting in the lower profile cases, or ones perhaps that are less culturally significant, we tend to see much more mixing of the justices.
All right, so the big ruling on the injunctions is it's backed by executive orders by President Trump. How do you feel about that? How does that strengthen the president's position?
It certainly will make it much more difficult for any opponents of President Trump's policies to challenge his actions. It's going to require now a nationwide effort. We can imagine something Birthright citizenship that's very established law that the 14th Amendment covers it. Nevertheless, to challenge it or to stop it and have an injunction, you're now going to need to file in almost every district court in the country, which is just a monumental fee and task.
On Medicaid, right, the providers, how does this give the state lawmakers clearly legal grounds to exclude such providers such as public health funding?
This is really going to be interesting to see it play out in the coming months and years. On the one hand, it gives states tremendous coercive power over healthcare providers, especially large conglomerates that operate many different services to end that reproductive services, even though they're not providing abortions. At the same time, it's going to also be interesting that constituents may start to push back as they see their health services curtailed. That's something, especially in rural areas, to have a healthcare provider anywhere close by is becoming more and more difficult as our shortage of doctors increases.
All right. Finally, parents may opt out of the LGBTQ theme lesson based on religious grounds. How do you see this ruling impacting education right here in Georgia?
This one's going to be interesting to watch. Had they decided on the rights of parents to upbringing of their children, it would have been much more in line with previous case law. Instead, they used the First Amendment religious freedom, which will now open up the ability of parents to challenge almost any aspect of public schooling that they dislike on religious grounds. So I think this one has the potential to upend our public education system.
So based on this particular ruling, you're saying anything that a certain religious group doesn't like, they can kind of, take it away from their children.
That seems to be where the court is going. This case and a few other recent ones, the ability of folks to challenge secular books, activities on religious grounds, the court seems to be, at least a 6-member majority of the court, is very determined to push forward. Again, it'll be interesting what the limit is. You can imagine parents are going to start using this to help their children, as rightly they should. But it will be interesting to see if this is a large can of worms or if the court walks it back fairly quickly.
Yeah. Were there any other rulings that caught your attention?
I think the other one is the Texas case limiting the access to pornography behind a parental wall. On the one hand, that's not a major surprise. Protecting children from pornography has been a steadfast part of the court since the 1970s. On the flip side, that it's going to give an outsized power to a state like Texas to dictate to providers what their websites look like and what verification software they put in place will be slightly interesting going forward. It'll also be to see if this is re-challenged on commerce grounds, which they did not raise in this current case. They relied on First Amendment free speech.
What's upcoming for the Supreme Court? Any upcoming cases that we need to know about?
I think the big one to keep an eye on is the 14th Amendment case is not done. That was never decided on the merits. It's been sent back to the district court. The Supreme Court paused it for 30 days to allow other cases to be filed in other district courts. So that is something to watch. I would be surprised if it wasn't back on the docket come October.
Now by 11 Live's Joe Ripley. Joe, you're hearing from people on both sides of the aisle here and the potential for some confusion to come out of this ruling.
Yeah, exactly, Cheryl. Let's make it clear, though, tonight. Birthright citizenship still stands as the law of the land, but future cases could help change what that looks like after the Supreme Court's ruling today. With the Supreme Court's ruling on federal injunctions, Emory law professor Jonathan Nash says it will limit district court rulings.
It sort of stifles litigation. So there is an argument that you'd like to have multiple district judges look at these claims and not just say one district judge can enter a ruling with respect to the whole country.
The law of birthright citizenship enshrined in the 14th Amendment of the Constitution remains unchanged, Nash says, but the Supreme Court's ruling shifts the power among the branches of government.
It's possible that we see this play out now in a bunch of smaller lawsuits, maybe state by state. Again, possibility of a nationwide class action.
That's exactly what Berenice Rodriguez is doing. The director of immigration rights group Georgia Casa says the ruling paves the way to change or get rid of birthright citizenship.
Ultimately, you're changing the status quo, and you will be creating chaos, anxiety, and fear. The biggest fear here is that they will eventually give birth, and they don't know where their children will stand.
Meantime, Georgia GOP Chair Josh McCoon calls the Supreme Court 6-3 ruling a win for the power of the presidency.
But it's going to be much harder now to stop federal action, even federal executive action, nationwide.
McCoon says the nation should adjust birthright citizenship to limit the ability for those who come into the country illegally to have children automatically become American citizens.
And it does create a lot of confusion. It creates a lot of difficulty in terms of enforcing our immigration laws.
Immigration laws that could change what it means to be a U.S. citizen.
We definitely are pushing forward protection for thousands and millions of future children that will be born.
And Professor Nash tells me tonight we are likely going to see several of these class action lawsuits across the country from advocacy groups, immigrants, and states themselves, all in an effort to ensure birthright citizenship stays in place and kids are not stripped of their citizenship.
All right, Joe, thanks a lot. The Supreme Court will likely rule on birthright citizenship eventually as more cases come up.
They were high-profile cases because no parents in this country had ever before been held criminally responsible for a mass shooting committed by their child. That fact not lost on Jennifer Crumbly, who spoke at her sentencing.
I understand this is a novel case and punishment expectations are high.
She and James...
I think this is that rare moment where those who are pro-Second Amendment and those who are more restrictive gun rights can agree on this.
Emory law professor John Acevedo says while gun rights in both Georgia and Michigan are fairly well protected, Americans in every corner of the country are fed up with the violence.
It really seems to be a combination of frustration by people that there's not a way to hold more accountability and to kind of stop these incidents from happening, as well as district attorneys looking for ways to discourage them from occurring again in their jurisdiction.
With charges against parents.
There is the danger of over-policing and over-prosecution that may come with this.
But he adds, responsible gun owners should have nothing to worry about.
The negligence in all these cases comes from parents not securing their guns in a proper way. That can be in a safe with a trigger lock by removing the ammunition from the house, keeping it separate if it is in the house.
President Donald Trump signing into law Thursday a congressional resolution that attempts to snuff out California's plans to phase out new gas-powered vehicles by 2035. Democrats call it hypocritical.
You'll hear every one of my colleagues here talk about the importance of states' rights, except when California does something that they don't like.
Moments after President Trump signed the resolution, California's Attorney General filed a lawsuit challenging Congress and the president in court.
The president and his administration are attempting to strip away California's long-standing legal authority to set clean vehicle standards, jeopardizing both clean air and high-paying green jobs.
The 1970 Federal Clean Air Act gives California the right to set pollution standards that are tougher than the national standard, as long as the federal government gives it a waiver to do so. In the 55 years since then, California received more than 100 such waivers, including one from President Joe Biden, allowing the state to issue its ban on new gas-powered vehicles by 2035, an effort to fight climate change by encouraging the switch to electric vehicles. That's the waiver targeted by the measure President Trump signed. The Attorney General's new lawsuit is the 26th legal challenge the state has mounted against the Trump administration since the president took office in January. One legal expert says this case may not be the strongest. He explained that because the federal government gave California the special right to have tougher pollution standards, it also has the power to take that right away.
The Clean Air Act is what regulates automobile emissions. California only has power to do something if Congress sees fit and the EPA sees fit to give California that power. So the only question is whether California can say that power was taken improperly from us. And I'm dubious on the long run whether California can make a strong case here.
Attorney General Bonta said he believes his office has spent or is on its way to spending $5 million of the $25 million war chest that the state legislature approved to battle the president in court. He called the return on investment enormous. In Washington, Cassie Simeon, Spectrum News.
Right, they are joining in with protesters in California calling for the release of people who they believe were wrongfully detained. Now, the protesters were right here where I'm standing, and it's right across the street from the ICE building over there. They made that decision so the people inside that building could hear their voices today. No justice! No peace! It was hard not to hear them Monday afternoon. The crowd here on Ted Turner Drive protested just steps away from the Immigration and Customs Enforcement building in downtown Atlanta. And I'm just going to take you inside of this protest you see here behind me. There are a number of people out here holding signs and flags. That sign right there reads, "Love wins." The protesters had one demand, the immediate release of SEIU California President David Herta.
We are demanding his freedom today, also the freedom of the other immigrant workers that are being unjustly detained.
Union of Southern Service Workers say ICE agents wrongfully assaulted and detained Herta. In a Twitter post, U.S. Attorney Bill Esseley defended the detainment, saying Herta deliberately obstructed agents as they attempted to execute a warrant at a L.A. work site.
I find what the federal government's doing currently as executive overreach.
For days now, we've seen both anti- and pro-immigration demonstrations across the country, some ending with arrests.
Protesters have the right to engage in peaceful protests.
Monday, Emory University professor John Acevedo explained a protester's rights and what could lead to arrest.
Don't obstruct streets. Don't try to enter buildings, even if other protesters are going in.
There were no arrests or any other problems at today's protest, and we are here live in downtown Atlanta. Audrey Washington, Channel 2 Action News.
Decision that the Supreme Court handed down yesterday is really saying is that plaintiffs who are bringing Title VII cases can't be held to different standards at that initial state of litigation based on whether they belong to majority or minority groups.
All right, given the current makeup of the Supreme Court, how surprised are you that this was a unanimous decision?
I'm actually not that surprised because the underlying analytic frame that the court was saying lower courts have to be held to has been around for a long time. This particular variation that's used by about 5 circuits covering 20 states has come in for a lot of criticism, and it doesn't sit well with Title VII's overall framework. So I think a lot of people were expecting this ruling.
Okay, this ruling touches on the Title VII of the Civil Court Act of 1964. What does it say, and how does that play into this ruling?
Title VII of the Civil Rights Act of 1964 is the federal statute that prohibits work-related discrimination based on your race, color, religion, sex, and national origin. And it generally applies to employers with 15 or more employees.
The case even has some strong connections to other Supreme Court rulings with ties to Metro Atlanta. How does that play into the role? In particular, the Bostock versus Clayton County. Compare that for us.
Yeah, so with both Bostock and with yesterday's ruling Ames, what the court is saying is that Title VII's focus really is on the individual. Now, the way that Bostock emphasized the individual is a little bit different from the way that Ames emphasized the individual. With Bostock, what the court was saying is that it doesn't matter how the group you belong to is treated if you as an individual are treated badly because of your membership in that group. With Ames, the court is saying it doesn't matter who the group is, whether it's a majority or a minority group, if you as an individual are treated badly because of your membership in that group. So the emphasis is a little bit different, but it's still on the individual.
So how can someone prove that they did not get a job because of discrimination?
It's always hard. The factual burden on plaintiffs in employment cases, and especially in employment discrimination cases, is always difficult. No question about that. But the important thing to remember is at this initial stage of litigation, which is what was at issue in Ames, yesterday's ruling, it is not on the plaintiff to prove that they were discriminated against in their employment decision. It's simply that they need to make a prima facie or preliminary case that they could have been discriminated against. And that could be anything as simple as saying, I applied for this position, I was qualified on paper for this position, and I didn't get this position. That should be enough to support an inference of discrimination.
Gotcha. All right. What does the decision mean for employers, especially at a time when DEI is being removed or lessened in many organizations?
I think what it does is it puts employers on notice that they need to be mindful how they treat all their employees. It doesn't matter if your employees are part of a majority group or a minority group. You can't treat them differently as individuals because of their membership in those groups.
If I feel like I've been discriminated against, who should I seek out for help?
Probably the first point of contact is going to be an HR official within your administration. After that, if you think that the issue hasn't been resolved and you want to pursue litigation, then you need to approach an attorney and probably the EEOC, the Equal Employment Opportunity Commission.
Yeah, there are the steps right there. Anything else we need to know?
I think this is a decision to watch because it means that the court is really honing in on its emphasis that Title VII is about individuals and how they are treated rather than on groups.
Do you think this will be challenged any further, or how do you think it will be challenged any further?
I don't see that happening because, for one, this is a Supreme Court ruling. Secondly, this is a relatively partial test. 5 circuits, less than half of the circuits in total, use it. And so there's wide precedent for other circuits using a standard framework where majority and minority group individuals are not treated differently.
All right, Professor Das Acevedo, really appreciate you joining us today and appreciate your insight on this topic.
Thank you so much for having me.
All right, take care now.
Welcome back. Well, the No Tax on Tips Act has the stamp of approval from the Senate. The House seems ready to approve it. It has bipartisan support, and Americans, as a rule, love it. But Fox 5 team's Dana Fowle says exempting tips from being taxed isn't quite perfect. It does have a lot of support, though, Dana.
It does have a lot of support. It sure does, but nothing's perfect, so we want to tell you about the flaws there. And just because there are a few things attached to it that many aren't aware of doesn't mean it's still not a good idea, but there are issues that you need to consider if you rely on tips for income.
I'm all for it, honestly.
For 16 years, Charlie Rhodes has earned a living in a tipping-reliant industry. He makes $2.13 an hour in wages, and the rest, well, it's tips. He said he and his co-workers are following the No Tax on Tips Act as it works its way through Congress.
It's like I'm getting all my money. I mean, you know, when you tax my tips, it's almost like I'm not getting like 2 out of my 10 tips, you know, so it's like I'm actually getting the money that I worked hard for.
So he's all in.
Thank you for having South Rose on the cab. How can I help you?
Kimyata Hardnett, a restaurant employee, is taking a wait-and-see attitude about the bipartisan bill that would let tipped employees exclude those gratuities from their income up to $160,000.
It's more so wait to see how it looks.
And Emory law professor Alex Zhang is someone who does look and delve into the details.
The bill would basically exempt all of those tips from federal income taxation.
That means if you make $200 in tips on a shift, you keep it all of it. The tax man gets none of it. But there's a catch, of course. Let's look at the Earned Income Tax Credit, or EITC. It's designed to give a tax break to low-income workers, people who work hard but struggle to get by. And here's why this matters. According to the IRS, it helps low to moderate income workers get tax breaks. If you qualify, you can use this credit to reduce the taxes that you owe, putting more money back into your pocket. And this No Tax on Tips Act, well, it can interfere with this. If you're not taxed on tipped income, per the IRS, it reduces what you earn. In turn, that can lower your earned income tax credit, which means you don't see the full tax break.
So they might make too little to be eligible for the earned income tax credit, and that actually takes away a huge welfare benefit for those families.
So finding the sweet spot between how much of your tips to claim and keeping the benefit of the EITC is tricky.
Right, how much tips do you report to not to count for the EITC? Right, I mean, there's a little bit of math to be worked out there.
The proposed bill is Senate approved, headed to the House, where it could be tweaked to account for this. But how many of the working poor are really being helped here?
Now I'm going to also tell you a couple problems with that, which is, well, a lot of lower income people don't work in tipped professions.
According to the Budget Lab at Yale, only 2.5% of American workers are in tipped trades. If the act is passed, the U.S. Treasury has 90 days to list the professions it considers eligible for the tax break. But it will certainly include restaurant staff, cosmetic industries, delivery drivers, and more. But a break is not necessarily what server and bartender Bethany Buckner is looking for.
I pay out the wads and taxes totally fine if I could see it around me in good use. As in education, streets, infrastructure, healthcare, libraries, you know, taking care of our sickest, our oldest. That's what I want. Like, I don't mind paying taxes on those things.
Now, there's a group that may also benefit here. That's the employers of tipped workers. Our professor says the bosses may feel like paying a little less now, as they assume their workers are now getting paid and not having to pay taxes on that payment.
So, I mean, this is kind of complicated at its core. You think
it is kind of complicated. I mean, no, it's not cut and dry at all. I mean, you've got to do this sort of balancing act, which is going to require you to do some math or take a look and estimate what, you know, your tips are going to be and how this is going to work with the earned income tax credit. You might end up actually having to hire someone to do your taxes to help you understand this. And will that take away from your savings? I don't know. That, you know, you've got that free file option within the platform of the IRS system, but we're not sure, according to our professor, how long that's going to last. So it's a lot to consider. It's not just a windfall. It's not going to be exactly that, but may not be a bad idea still.
Sure. Yeah. All right. We will see, right?
Yeah, we'll see. Well, we'll see. We'll hear about it next year.
Sure. Dana, thank you. We appreciate it. It's 9:14 now.
Channel 2's Brittany Kleinpeter joining us live now from Atlanta Police Headquarters. And Brittany, APD, they shared body cam footage with you. It's of 2 arrests, hoping at this point to talk about the challenges they face with these repeat offenders.
Emory law professor Lindsay Barron says the issues surrounding why someone who commits a crime can be back out in society so quickly are complex, but an issue that needs to be addressed at a deeper level.
I think across the board, better discretion needs to be exercised by judges, by DAs, in terms of who really does pose a risk of flight or a risk of danger to the community.
News here on 90.1 WABE from Atlanta. I'm Rose Scott, where I'm in conversation with Georgia State University constitutional law professor Anthony Michael Christ, and from Emory University, Jonathan Nash, also professor of law. We're talking about the Supreme Court of the United States recent ruling, or for some would say decision, regarding birthright citizenship.